So I'm going to invite Herman Schwartz to come up next and transition us into the second part of the event, which I mentioned will be on Arthur's role in both forming and interpreting the South African Constitution. So, Herman, to you.
I'm a newcomer to this circle of Arthur's friends and admirers, and I'll be relatively brief because so much has been said so beautifully and so thoughtfully. I'm also, although I've spent some time studying the South African Constitution in my classes, I'm not an expert on South African law. And on that, I'll defer to Frank Michelman, who has spent a great deal of time on it. And as you heard, there's been a conference dedicated to South African law, focusing on his work. What I want to do is talk a little bit about what I take to be, what I've taken to be, what was central to his thinking as a constitutional lawyer, and also to his personal philosophy. I had met Arthur briefly many years ago when Lloyd Cutler, who was a great friend and staunch American supporter in many ways of the Legal Resources Center, Lloyd Cutler invited me to a fundraiser, a dinner to meet Arthur, and then I spent several days with him in Israel back in the late 1990s. His brother lived in Israel, and we had a conference there. And we really became quite friendly a couple of years ago when he was visiting here. Not only did we share what might be called an academic interest in human rights, in his case much more than that, but we had each worked as both private lawyers and as public interest lawyers, litigating in often very unfriendly courtrooms, and knew how hard and how heartbreaking that could be, and how sweet the occasional victories. We were also both Jewish. Fran Buntman has talked about that aspect of being an outsider. At one point, Arthur was quoted in one of the obituaries as saying he was doubly an outsider. He was not part of the British elite, and of course he was not part of the Afrikaner world. And growing up in the 30s, Arthur and I were almost exactly the same age. He was 1 month older than I, and we had each been married the same year. Growing up, we knew what it was like to be an outsider, and I would guess that to some extent that shaped the kinds of careers each of us chose. Equally important to our friendship was the fact that the two couples hit it off so well when they were here and shared so many other interests, especially an interest in English literature and particularly poetry. Lorraine was not only a lecturer in English literature, and you've heard, which I didn't know, what a superb teacher she was, but she was also a noted poet. And the four of us devoted a lot of time reading and talking about poetry, both in my home and then when I visited them and stayed with them for several days in South Africa, and discovered this peculiar aspect of South African people in having an aversion to central heating. It was an unseasonably cold time in May, and they, I think, in a not atypical way, massed all of their space heaters in the bedroom to which I was assigned, and made it through the time. What I think struck one about Arthur, struck one on first meeting him, is that this famous, truly great man, this giant who had done so much for his country, and even after he left the court was so active internationally. The last time I saw him, he was on his way to Budapest for a big conference on developing principles reconciling national security and the right to know. And he was at that time trying to fight some very repressive legislation that was being proposed relating to speech in opposition. But what really struck me, and I think others as well, is that he was so unassuming that he seemed almost deferential. And I think this reflected something profound and deeply rooted in Arthur's mind, and for want of a better word, heart. His respect for the dignity, and I'm quoting him here, the inherent infinite worth, his phrase, I said, of every human being. As he told us in his speech here 2.5 years ago, the South African Constitution, which he helped to write, insists that, and again I'm quoting from his speech now, all human beings, regardless of their position in society, must be accorded equal dignity, and requires us at the least to acknowledge the value and worth of all individuals as members of our society. This principle was reflected in his great opinion abolishing the death penalty, the first great decision of his court, and as almost everywhere in the world, intensely unpopular. There he wrote, quote, everyone, including the most abominable being, has a right to life. This opinion, by the way, reflects another of his truly great virtues, a realism that grew out of his experience fighting daily for the most basic human rights, experience that brought home to him, who was the child of comfortable parents, who'd gone to boarding school, who'd been a very successful private lawyer on behalf of private clients, brought home to him the continual crises about food, shelter, health that afflicted the lives of his apartheid-plagued clients. If you want an opportunity, if you want to take the opportunity to read a truly great opinion, including the footnotes, read that opinion. Not only does he do a careful and thorough analysis of scores and scores of capital punishment cases from around the world, but mostly he sets out the terrible difficulties that defendants face in death penalty cases, not just unfriendly courts or juries or something like that in my country. He sets out the difficulties that come from a shortage, a desperate shortage of competent defense counsel and a lack of other necessary resources, investigational resources, expert witnesses, psychological experts, and the like. In our country today, it's just as bad as it was perhaps in South Africa when Arthur was writing. This realism, I am sad to say, has been very absent from the opinions upholding capital punishment of our Supreme Court. You just have to compare the Makwanyane case with the Gregg case to get a sense of being in a totally different world. Arthur's is a world of human beings. Justice Stewart's is a world of not terribly persuasive abstract principles. This mixture of principle and realism also appears in his opinions striking down discrimination of various kinds, racial, gender, same-sex, as well as in his comments on the importance of economic rights, like the right to health and to housing. I know from personal knowledge that his opinion in the Groteboom case converted one of the leading opponents of economic and social rights, Cass Sunstein, who originally expressed himself as saying these rights have no business in a constitution. Sunstein's more recent book about, I think, a second New Deal suddenly champions these rights. This also informed his views on group discrimination. He knew that discrimination can become institutionalized. He wrote, "Ongoing discrimination builds patterns of group disadvantages and harms." He saw how these institutionalized discriminations worked into the foundations, often not visible unless one look closely, which few people will do, certainly few people in public life, into the foundations of economic, educational, and other social structures. It is more than simply a bad man doing nasty things, as our Supreme Court seems to think when interpreting our Constitution. Arthur was a very blessed man. He was born with many, many gifts, and over the years he developed many more. But of them all, one of the great gifts he was given was what you have already heard from Fran and others, a truly wonderful marriage. I want to close with a few comments about that. I don't know others in his family, but I was fortunate to spend time with him and Lorraine when I was there and when they were here. With her permission, I want to read to you an excerpt from an email she sent me last week that gives those who didn't know them as a couple an idea of what they meant to each other. And this is what Lorraine wrote in her email. Below is a poem I wrote to Arthur in 2011. I mistakenly typed 2001. In 2011, which I read to him at a magical birthday party when I turned 70 in October last year. Our grandchildren and children and about 40 close friends here were there, and the children, biological and by marriage, and the older grandchildren addressed me. It was an evening filled with love. And then she sends this poem. By means other, that was the title. I've never written one word in a poem that's overtly about you. Words are cheap, you told me once. Not to me, I replied. But faced with saying something apposite about my love of you and yours of me, I'm silenced.
Well, we have heard this morning a series of gripping, eloquent, heartfelt evocations of Arthur Chaskalson and his life and accomplishments. I want to say it's a genuine privilege to have a part in this. I think in Sean's conception of the program, I come along with Professor Schwartz, come in the parade along with Professor Schwartz in the brigade of academic pundits whose role it is to expound on Justice Chaskalson's prowess as a constitutional jurist, perhaps with some reference to his having led the Constitutional Court of South Africa in a remarkably short period of years to a position of absolutely top-flight prominence in the minds and opinions of the world's constitutionalists, the world's legal constitutionalists, along with the courts of a few other countries, perhaps including ours. Perhaps including ours. I speak now of what's sometimes been called the global conversation of judges and others concerned with constitutional law. Arthur Chaskalson had a hand in writing the Constitution and more than a hand in leading the court that has achieved that level of eminence in an amazingly short period of time. A year or so ago, it happens that a person who is an eminent constitutional jurist in her own right had occasion to put to me the question of who would come immediately to mind for me as my model of a great constitutional judge. And I immediately answered Arthur Chaskalson. And my questioner, I think, was, she showed by her response that she was a little bit startled by what I had said. I think that's because she, knowing what she did know about my own personal history and associations and writings, she had more or less figured out in her own mind that I would come up with another name. And indeed I might have, but it happens that I came up with that of Justice Chaskalson. I think that part of what was in my mind as I answered the question was, well, she said a great constitutional judge, and that's the question I'm supposed to answer, but somehow or other there was entering into my mind the sense I had of Justice Chaskalson as Arthur Chaskalson, the man whose full biography we've been hearing a good deal about this morning, who made his contribution to the party of humanity in roles that surely most saliently include his role as President and Chief Justice of the South African Constitutional Court, but so much more. I want to look at, well, I'll call him Justice Chaskalson. Towards the end, I won't say, I am going to try to save, academic pundit though I may be, I want to try to save a few minutes towards the end of these remarks for my own personal recollection of Arthur. He will become Arthur at that point, but I will try to keep him Justice or Chief Justice or President Chaskalson for a little while. I want to look at his accomplishment through a framework of a subdiscipline that has, in recent years, taken root, typically at home in departments of government or political science. It goes by the name of judicial politics. These are political scientists who try to be hard-headed and realistic in looking at the conduct, the strategy, tactics, successes and failures of courts, and particularly constitutional courts, from the standpoint of assigning these institutions a certain role in the conduct of the affairs of their countries. And that role is to exert influence over time in the direction of inducing the conformity of the powers that be in that country to sets of principles, rules, and values that are represented in typically a written instrument known as the Constitution of the country. The job of a constitutional court is to do what it can through the mechanisms of law and adjudication and so forth to keep the actual practice of the deployment of political power in that country in some kind of conformity, some degree of conformity to the ideals represented by the Constitution. And that doesn't just mean today, it means today and tomorrow and over time. And you calculate the success or failure of this judicial institution by some kind of function that adds up what it has been able to do over a period of time. And of course that means that a court must always act in accordance with an interest in, well, there are many expressions for this: living to fight another day, keeping your powder dry, maintaining your influence and your ability to influence how things go over time. I'm taking a page here out of a book that's not yet on the shelves, but will be sometime soon. It's being written by a South African scholar by the name of Tunis Roo, who is working now in Australia. It will be a kind of a history of the Chaskalson court looked at through this framework of judicial politics. And it is going to be a fine book, I might say, so keep your eye peeled for it. Tunis, I think, does a very nice job of lining up the factors that will inevitably enter into the choices made by constitutional judges who are situated in a social and political environment. So we have considerations of legal legitimacy, social legitimacy, institutional security, and I'm going to add one more to Tunis's list that I will call something like personal legitimacy. The court won't succeed unless its judgments are plausible, acceptable, robustly plausible and acceptable to the community of knowledgeable lawyers as legal decisions, as decisions made in accordance with the legal texts and the methods of reasoning, argument, inference, and so forth that are known to and shared by the community of lawyers. Legal legitimacy. Social legitimacy. Well, the court is supposed to be in the business of maintaining and exerting the influence of the Constitution on the conduct of a country's affairs over time. And that project is going to fail if the mass of people in a country lose confidence in the Constitution or in the court. So the court, how does the court deal with the question of the death penalty in South Africa? The question of social legitimacy is involved. Institutional security. Well, not to put too fine a point on it, in South Africa that means not getting too much on the wrong side of the ANC. It means conducting yourself in a way that does not exceed the ultimate bounds of tolerance of the real powers that be for the time being in a country. That's quite an equation now if you put those three together. Now my fourth one, personal legitimacy. The judge goes home at night. The judge has to eat dinner with Lorraine or whoever it might be and sleep. That is to say, the judge has to be seeing, construing, constructing, enforcing a constitutional order of values that judge is prepared to put his life and destiny on the line for in supporting. Or the judge is going to live a life of extreme cognitive dissonance. Now, of course, I refer to cognitive dissonance, and judges have lots of ways of dealing with this. They can quit if they can't bring constitutional law into line with something they regard as humanly decent and acceptable, and that's a course of action which has, at certain times in history, been urged on judges in certain countries, including South Africa in the 70s and 80s, and the United States in the 1840s and 50s when slave laws came before courts for enforcement. Or they can, as Robert Cover, an American scholar of past notes, said, they can lie. That is, they can pretend the law is okay when it's not. That is to say, when as a matter of legal legitimacy, it's not. Or they can create. That is to say, and we've heard lots this morning about how Arthur and his cohort of liberation-minded South African lawyers were able to do this over the decades in apartheid-era South Africa. They can show how the law that might not at first look on its face be supportive of a humanly acceptable outcome, in fact is and does dictate such an outcome. Or they can be lucky and have a constitutional order to support and to enforce that matches up pretty well with their own sense of human decency. And of course, if you happen to be a major author of the constitutional instrument that you're assigned to enforce, that can make life a little easier. All of which is to say that we can read out of the judgments of the South African Constitutional Court, including but not necessarily limited to those written in the chambers of President or Chief Justice Chaskalson, some sense of his own ordering, his own internal ordering of constitutional values. And what do we see? We look around the world and we see those of us of a roughly speaking progressive egalitarian liberal constitutionalist persuasion, we see that's the court and that's the Constitution we would really like to have in our own country. Herman's already, in his own words, expressed the same sentiment. And Arthur's on both ends of that as author and reader. And it does a lot to explain this reputational level of the South African constitutional project having been achieved in such a short time. I want to mention, now you can see what I have to say. I can mention judgment after judgment where Arthur, you can see Arthur's hand operating with consummate skill and deftness, negotiating the way through legal legitimacy, social legitimacy, institutional security, and personal legitimacy. Knowing when to decide and when not to decide, I want to mention one specific instance of this, a case that came up within the first few months of the court's life in 1996, a fairly obscure case that you may not have heard of called Ferreira against Levin. Ferreira against Levin started out life as a bankruptcy case. It involves an officer of a bankrupt company who's called by subpoenaed by the administrator of that company's affairs to come and give testimony about its finances. And to use American lingo, this officer wants to take the fifth. He's anticipating getting into some trouble. the interim constitution, which was in force at that time, does provide for a privilege against self-incrimination, but only for accused persons, and there was a doubt about whether this particular individual was, as of the date he came to court, in the position of an accused person. Now, I'm going to cut through some stuff pretty fast. It doesn't, it looks like a significant constitutional case, but not a world-shaking one. You could imagine that a Chaskalson-led court would find its way to providing some relief for the petitioner, which it did. What's interesting about the case is that one of Arthur's colleagues, and one whom I hold in very high esteem, Justice Laurie Ackerman, believed, or at any rate tried to persuade his colleagues, that this case presented a much more profound question. South African Constitution guarantees just about everything that American constitutional lawyers would think of as falling within the boundaries of so-called fundamental rights or fundamental liberties. Equality, dignity, life, privacy, expression, religion, political rights, freedom of movement, freedom of trade and occupation, property. What Justice Ackerman wanted to know was, well, doesn't it provide some degree of protection for just plain freedom, just plain, what Louis Brandeis called the right to be let alone? Isn't there something in this Constitution that requires the state to go on the carpet and justify every legislated encumbrance or restriction on negative liberty? That is a profound question. There was a clause in the interim Constitution giving everyone the right to freedom and security of the person, but that clause was more plausibly read to create rights against physical abuse and immobilization, rights against unjustified imprisonment or torture or the like, and not to create this general umbrella of freedom. Justice Ackerman gave as examples the freedom to possess a gun, which might ring bells for some Americans. He gave as another example the freedom to play sport on Sunday. He said, I can't see any place outside of the Freedom Clause where these are guaranteed, so that the state would have to justify any infringements under the justification clauses of the Constitutions. And this is a case in which we could make the pronouncement that just plain freedom is protected under our Constitution. Well, in a culture, in a milieu, where the word Ubuntu marks a complex ideal of human relations, whose meanings seem to unfold endlessly, for a constitutional court so early in its career to have taken a stand on Justice Ackerman's question. Would you want to say, no, just plain freedom isn't a value in the South African constitutional order of values? What? Would you want to say, yes, the freedom of the individual to separate herself or himself from the community by asserting that kind of a right gets recognition here in the South African context? To pronounce on that proposition, I believe, at that stage of the court's life would not have been judicious. It would not have struck the right note. And in what I will call a virtuoso performance of legal skill and command, President Chaskalson led the court to a disposition in which the applicant's quest for constitutional protection was successful and in which Ackerman's question was left undecided, as it remains to this day in South African constitutional jurisprudence. Now, may I take 1 minute more for my personal recollection? I take you to a place some of you may have heard of and some of you will not have heard of, called Onrus. Onrus is a town on the Western Cape Sea coast. It's not far from Hermanus. Onrus is the site of an establishment, if I can call it that, called Camp Habonim, Habonim Camp. Well, if there are Hebrew speakers among you, Habonim, you will know, is a Hebrew word for builders. And I think the name of the camp must come from Habonim Dror, Builders of Justice, which is a network of civil society organizations that has had a foothold in southern Africa with labor associations. I'm sure that the name of the camp must have come from Habonim Dror. It was a Jewish boys' summer camp. It's not, and girls too. It is not a luxury conference site. Its accommodations are rustic. The meeting places have roofs, all of them, walls, some of them, all metal, all packed earth floors, a dining hall, dorms. What does it have to do with us? Well, it has to do with Builders of Justice. It has to do with the South African organization called Students for Law and Social Justice, which is an organization of law students and recent law graduates who feel a calling towards the furtherance of the constitutional democratic project in South Africa along the lines of the interim and final constitutions. They have an annual Western Cape Regional Conference at Camp Habonim for 3 days. The time I was there were 300 or 400 students in attendance, alert, attentive, excited. They ask people to come and speak. Dignitaries. Arthur Chaskalson went every year. This was 2010. It was 5 years after his retirement from the Chief Justiceship. I have two recollections about Arthur at Camp Habonim. One of them is that I was in a position of requiring transportation. The old guys who were speaking there didn't sleep at Habonim Camp. It was too rough. So we would get driven, or drive back and forth into town where there were nice accommodations. It's a seaside resort town. Arthur was my schlepper. He drove me around. We were friends by that time, but still it struck me that I was being schlepped by the recently retired Chief Justice of South Africa. One of the main events of a Camp Habonim gathering of SLSJ was a campfire. The last night of the gathering, after dinner, after dark, it's August, so it was dark early, there was a big fire built in a campfire ring, and 400 students would come packed, gathering around the fire. And one of the main events each year was, it was a kind of a pep rally, and there was a speech from Arthur Chaskalson. And there Arthur is, in the firelight, flickering off his face and torso, extemporaneously addressing this group of students on the values and commitments and the current state of success or failure and the political threats and everything else to the constitutional project of South Africa. And it's the image of Arthur, above all others I have, that has remained implanted in my mind. Dean Grossman said when we began that Arthur was extremely committed to education. Indeed, he was. He was dedicated to the rooting and the flourishing in the minds and spirits of the young, the seed of a legacy, and it would have been a legacy from him and his cohort of South African great legal fighters for justice, a legacy of constitutional government for his country. No one conceivably could have made a more honorable, distinguished, enduring, and glorious contribution to that project than Arthur.
Thanks. I'd like to thank Sean and company for this event, as well as the opportunity to come and share my own reflections about this giant of ours. Now, apartheid was quite devastating as an economic system, especially for us as black people, where we were exploited for many, many years. We denied access to land and many other things. So it was a great privilege for me as a young man to join the South African Human Rights Commission in 1996 as head of research, with the main responsibility of monitoring how our new government is basically going to address issues of socio-economic rights, address issues of poverty and underdevelopment. And it was not an easy job because you had in government two bad elements. The first element were the guys who were there all along, who have been exploiting us, and now suddenly they have to do the opposite. The second element was my own comrades in the struggle, who were suddenly having to account to other people on what they're doing in realizing this rights in the Constitution, and being criticized for their failures, and they didn't take that kindly. So it was quite a tough job. In most cases, government departments would not even bother to report to the Human Rights Commission as per the Constitution, as per the provisions of the Constitution. Now, however, out of the blue and miraculously, somebody said the following: we live in a society in which there are great disparities in wealth. Millions of people are living in deplorable conditions and in great poverty. There is a high level of unemployment, inadequate social security, and many do not have access to clean water or to adequate health services. These conditions already existed when the Constitution was adopted, and a commitment to address them and to transform our society into one in which there will be human dignity, freedom, and equality lies at the heart of our new constitutional order. For as long as these conditions continue to exist, that aspiration will have a hollow ring. This was Arthur Chaskalson in Subramani judgment, and we laughed him because now we're able to use this judgment and many other judgments which follow to say it's not just us, he's the President of the Constitutional Court. Just around then, I was in Salzburg, in Austria, and where a famous British jurist, Lord Lister, was saying to us, and I think Judge Ginsburg was also there, saying, you guys are out there, you live in your own world. There's no way you're going to enforce socio-economic rights. So we said, but Arthur says we can. So for that, Arthur was really a hero to us, and he definitely made my work in the commission for over 13 years a much easier task, although not 100% easy. So for that, we'll forever be grateful. And of course, the Human Rights Commission had a major relationship with the court and Arthur, and the judgments basically made our work easy, not just on socio-economic rights, on equality, and many other aspects of life. Now, on the second point of building a court, certainly Arthur Chaskalson contributed to giving credibility to our judiciary and to our law. Those of us who lived under apartheid hated the judiciary and hated the law. One of my roommates got 10 years in Robben Island for blowing up the Supreme Court of Justice in Pietermaritzburg. I was 18 years old then, and actually I went to court for his trial and I got arrested. That was the first time my parents found out that actually their son was involved in illegal activities underground. But certainly today, after many, many years, clearly South Africans see the court and the judiciary as the protector of human rights and protector of our democracy. Whereas before we used to see the court and the law, as a former member of the Communist Party, we should see the law as a tool of the oppressors. But now I think today law is being seen to a large extent as a tool, as a liberation tool, a tool to protect people and advance our democracy. So again, we are very grateful for that. Now, as people were talking, I was thinking, you know, has Arthur Chaskalson really received the credit outside academic circles he really deserves? Because I was saying to myself, in the history of the country, what other great personality comes after Nelson Mandela? And of course, we see Nelson Mandela as the miracle, that without Nelson Mandela, probably South Africa would not be where it is today. But I certainly believe that without Arthur Chaskalson, the respect, the dignity of the law in the country and the judiciary would not be where it is today. It required someone like Arthur Chaskalson, with his own experiences as part of Mandela's legal team and many other things, to be able to actually restore or build that credibility of the court and respect for the law. So for that, we will forever be grateful. Now, in his last remaining months on this side of the earth, he made another speech which I think was quite important in May 2012, when again he was being asked what constitutes the greatest threat to our constitution and our constitutional democracy. And he said the following: the danger to the constitution lies elsewhere. It is in the poverty and inequality in our society and the corruption, poor education, and related challenges. If they are not effectively addressed, our constitution will indeed be in danger. Maybe that's why my comrades in the Communist Party decided to claim Arthur Chaskalson as a member of the Communist Party. Of course, there's a great controversy there. But for me, this actually shows that, you know, Arthur Chaskalson, amongst many things else, continued in a consistent manner in being concerned about the plight of the poor, the plight of the marginalized. And I think as time goes on, ordinary people in the country will really appreciate that this was indeed one of the other giants the country had after Mandela and, of course, Comrade Slovo. Now, a few years ago, I was addressing the Jewish Board of Deputies, and I was saying, you know, one of the reasons why in South Africa you have very low levels of anti-Semitism behavior is because back in the townships, the people know Comrade Slovo, that this is the man who basically led the struggle and was prepared to die for their liberation. And I'm sure a few years later, they'll be talking of another Comrade Arthur Chaskalson. Thank you.
I suspect there's a certain benefit to being the last speaker in an event like this. I had asked Sean, because in many respects, I kind of coincided with what turned out to be the last phase in this brilliant career. But I want to say that the man who I have heard described this morning is indeed the man who I had such great admiration and affection for. And I want to say a few things about this last phase because we worked very intensely together. I first met Arthur in Berlin in August of 2004. Arthur had been elected president of the International Commission of Jurists. And there was a meeting that was marking the 50th anniversary of the founding of the International Commission of Jurists, which was founded in Berlin. And the meeting was against the backdrop of concern by the 164 jurists who came, many of them judges, who came from around the world, about the way major democracies, and particularly the United States, was pursuing anti-terrorism in the wake of the September 11 attacks in the United States. I briefly met Arthur then. I had just taken up a position with a mandate within the UN to examine counterterrorism policies and how they were complying with states' obligations. It was an extremely useful meeting, and what I could see later was Arthur's hand was written throughout the Berlin Declaration, 11 very simple but eloquent principles on how to deal with upholding the rule of law and so forth in fighting terrorism. In October of 2005, obviously reflecting a continuation of concern and policies that were taking place worldwide, the ICJ decided to create a panel who would have a mandate to go around the world and to assess what the effect of laws and policies enacted since September 11 on human rights, IHL, the law of armed conflict, and the rule of law. And quite sensibly, Arthur was named the chair of the group. There were 8 members, and it was a fairly high-powered group. Mary Robinson, who is the former president of Ireland and High Commissioner for Human Rights, was one of the members. Georges Abissab, who was one of the leading experts in the world on the law of armed conflict, who had been a judge on the Yugoslav tribunal. I could go on. I was one of them. I was kind of the runt of the litter, and Arthur took me under his wing, and I will be forever grateful about that. What we really did was unprecedented. There are many good studies that had been done within country, within regions, about the effect of measures from 9/11 and so forth. But no organization had ever attempted to do something like this, that over a 3-year period to conduct 16 hearings at the regional and sub-regional level, covering 40 countries in every place in the world to assess what the impact of policies and so forth and so on since 9/11 were on the enjoyment of human rights and on the rule of law. And let me tell you that I could see why Arthur was so skilled, because not only dealing with our group, where you had a group of, as I said, there were some prima donnas and people with different ideas and moving in different directions, but it was a small enough group, very much like a commission or like a court. And Arthur soon had us playing like a symphony. And we would divide, and in the key hearings, we would go ourselves, such as the hearings that were held in the United States. They were held in this room, and I can look back and see Arthur sitting in that seat, or in our hearings in London. And it was important to have the credibility of Arthur Chaskalson, both to hear the testimonies of persons who were family members of victims of counterterrorism policy and so forth and so on, as well as dealing with members of the government itself. And something that I could see the kind of genius of Arthur at work during these hearings. And there was one point in particular where we had in London in the hearings, which were several days. And the hearings at one particular point were centering on the issue of control orders. And it was testimony that was being given at that moment by Charles Clark. Now, Charles Clark was the Home Secretary, and he was Tony Blair's right-hand man in the cabinet. And at one point in an exchange with Arthur, Clark said, "Well, Mr. Justice, I really just don't think you know what you're talking about. You just really don't quite appreciate what, we're trying to do." One thing that I noticed about Arthur never got angry. And when Arthur wanted to make a point, he did not raise his voice, he lowered his voice. And Arthur looked him in the eye, and Arthur said that he had had some experience with comparable measures as an advocate in South Africa. And you could see on Clark's face, he immediately, profusely apologized for the remark that he had made. During these hearings, and also, I recall going up and seeing Lord Bingham with Arthur, or when we went to Canada to do the hearings, and Arthur and I with members of staff, and the Constitutional Court held a luncheon in our honor. Really, I accompanied Arthur and so forth. And the thing is, you could see the absolute almost reverence, if not esteem, with which these jurists held Arthur and so forth. I was pleased that Arthur, as I said, he took me somewhat under his wing. And when you have so many chiefs and no Indians on a commission like this, you can't write by committee. And one of the things is, after having taken over 3 years, over 10,000 pages of testimony and so forth, we knew we had to write a report that was going to be readable, and we had to get it out. And so Arthur asked me and Georges Abissab to form the subcommittee that basically, with others, we would write basic parts of the report. And that required me to go and travel every couple of months. Arthur would travel from South Africa to Geneva, and we would work long days and nights. I never saw him get frustrated. I never saw him get angry with staff. And I could see how he could conciliate things, how we would move in a certain direction and so forth. And what resulted in terms of the report, which was extremely well received internationally, I think was because of the kind of judgment that Arthur brought to bear. It has its hallmarks of his thinking as I said, this kind of an approach that was moderate in tone. The man knew how to choose an adjective. He knew the proper adjective to use at the proper time. Now you can imagine how pleased I was when Claudio Grossman, my colleague here, at one point we were talking about visitors, and I said, let's bring Arthur. And to my everlasting joy, he and Lorraine came here for almost a 6-month period. And the issue came up, well, what was Arthur going to teach? And one of the things that, of course, was a natural was kind of a comparative constitutional approach and so forth on selective issues of, particularly of different courts would handle a variety of issues. And that Arthur was going to do alone, but then Arthur and I were going to do something together. And we came up, we said we're going to teach a course on human rights and terrorism. Now, there are plenty of books on terrorism and national security law, but try finding one that deals with cases and materials that deal with human rights and terrorism. You will not find them. And so over the course of a summer, Arthur and I worked in putting together something. And what I saw that was so important, Arthur wanted to make sure, particularly at a U.S. law school, that they would see that there were other liberal democracies with courts that could have issues before them that touched on sensitive national nerves, where victims of rendition or victims of false arrest or victims of other kinds of abuses that were committed could have access to court, could fully litigate their case. They wouldn't be thrown out on standing. They wouldn't be thrown out on the application of doctrines that, in a sense, of national security, to even litigate this issue would possibly imperil the national security of the issues. So we selected cases by the law lords where they would strike down legislation and so forth, or where the law lords would put limits on control orders and so forth, and routinely apply human rights law. They would read cases of Canadian constitutional jurisprudence, striking down various provisions. Decisions by the European Court of Justice, decisions by the Inter-American Commission on Human Rights ordering provisional measures for the detainees in Guantanamo Bay so they would not be placed in a black hole. In other words, it was putting together, and this was Arthur's idea and so forth, that they could see that there were other approaches to dealing with the serious issues of terrorism that effectively did not preclude the judiciary from providing effective remedies and so forth, and the primary role that they had in upholding human dignity and fundamental rights. I've continued to teach that course on my own, and I can tell you that teaching with Arthur, we actually had a shadow teacher, and that was Lorraine. Arthur's office was next to me, and Arthur would come in before a class, and he'd say, I discussed the assignment with Lorraine last night, and she had the terrific idea. And she said, what we're going to do is make a presentation in the students, and then we're going to divide them up in groups, and they are going to have to draft, over a half an hour, their own anti-terrorism law and defend it. And we're going to have some spontaneity, and then we divided into teams in this, and I've continued to use this, and I told Lorraine that this was an extremely effective thing. At first I told Arthur I didn't know, but this was very traditional, but this would be terribly good, but it worked out beautifully. But in a sense, it was a metaphor for what we've heard today about that extraordinary relationship of husband and wife. Arthur was a very great man, but she's an equally great woman. And I think they complemented one another and so forth. So let me conclude by saying I've been extremely blessed in a life and in my field in human rights. I'd like to believe I've done some important things. But I do know that over 40-some years, there are very few people in this field I do not know or I have not worked with. And I can say this and not being moved by the moment. None were greater than Arthur. And not only were none not greater, none were more human and more modest. And it's something that will be with me for the rest of my life. Thank you.
So we've drawn to the close of our formal list of speakers, and we have a little bit of time left over. And if anybody would like to make a further comment or remark, we would be happy to entertain it. Okay. So I think we're going to close here. So thank you, everyone, really, for coming. This has been truly an A-plus day. I mean, Frank mentioned to me at the break that he thought that everyone really performed to the call today and spent a lot of time thinking about the issue and preparing incredibly insightful comments. And it really was beyond our expectations to be able to pull this together. And I'm incredibly looking forward to Friday to doing this once more again and continuing to relive this experience all we can. As I mentioned on the onset, we will be putting the webcast out for on-demand viewing later. There's a page on the American University Center for Human Rights and Humanitarian Law's website, and it will go there. But we will also share it with others, and we will be talking to the South African Legal Foundation on Friday and seeing if they want to put it on their page. And if any of you are members of organizations or have access to web pages and things you'd like to share this link with, we're happy to put it there. And I very much welcome any other ideas about what all of us can be doing together to continue this journey we've started. And as a final moment of thanks, it's just been just an incredibly warming and just a great experience putting together this network, really, and I hope we can continue to use it together. I got the opportunity to reach out to many people who I've wanted to know, many people whose work I've been studying. Some of you who I contacted over a dozen years ago exploring my own trip to South Africa and asking for advice and assistance and contacts, and many of those contacts led to Jeff and to Arthur for the reasons that we've contemplated today. So it's great to have you all here, and now we can go and have lunch together and continue to become better and better friends. So thank you very much.